TVASIA Telugu ప్రేక్షకులందరికీ hello and welcome back to yet another fantastic episode of our talk show with experts. మనతో ఉన్నారు మన expert Rahul Reddy garu. Rahul garu, thank you so much for being on the show.
Thanks for inviting, and it's a pleasure to always come on a Sunday and help people out. Thanks very much for inviting me.
Thanks, sir. And tomorrow is the National Women's Day in Mata, so I would like to, on behalf of TVASIA Telugu and for Rahul Reddy garu as well, wish everybody happy Women's Day, to all your moms, sisters, daughters. I just hope you have a fabulous day tomorrow. And Rahul garu, on that note, let's get started, Andy.
Sure.
Okay. So for today's topic, we have about the filing of the I-485 adjustment of status, right? We want to talk about like what happens next on Mata. We have 40,000 plus people who file for adjustment of status. Can they now use the EAD, or do they have to maintain their H1B and H4, etc.? Can you just elaborate a little on that, Rahul garu?
It's actually 400 plus thousand, Andy.
The people who I'm sorry.
That's fine. And it so happens that most of the people who filed adjustment of status, especially in the month of October and November, employment-based happens to be Indians, because the priority date for Indians have moved very much. So this, since we are addressing now, coming to the point though, once you file the adjustment of status, obviously you will receive the receipt notices. If you have not already filed an EAD and AP, you can always file it afterwards, right now with the receipt notice. And a lot of people have filed for I-140 also. I'm going to explain them, both the people separately. Let's assume that you already have an I-140 approval. You didn't file for the I-140 downgrade.
Okay.
You will be, people will be getting the EAD and advance parole up. They may be getting anywhere from 2 months. It may take all the way to 10 months to get the EAD and advance parole.
Oh, wow. Okay.
That's one.
Okay.
Second is that for the people who file the I-140 approval, they'll get an I-140 receipt notice. I strongly suggest everybody to upgrade their I-140 to premium processing.
Okay.
Because you don't want to be hanging around if there is something that the denial is going to come. Not many denials we see in the 485, but those denials that we see, most of them are because the I-140 has been denied. Okay. So I would rather want to get the result soon if there is any corrective actions that can be taken, rather than going further. Maybe you change the company and you get an I-140 approval. So that's one of the things that people need to remember, especially for the downgrade people.
Okay.
Coming to the $1 million question, do you need to maintain the H1B after you get an EAD? That's the $1 million question. If you do have kids who are teenagers though, we strongly recommend that you don't file a premium processing of I-140. We have explained in the previous TVASIA things that why you should not file premium processing if you have teenage kids. If you and once the I-140 is approved, and it's been more than 6 months that the I-140 is approved.
Okay.
I'm sorry. I-140 has approved, and adjustment of status has been pending for more than 180 days. And once you receive the EAD approvals, do we need to maintain the H1B? Do not need to maintain the H1B?
Right.
And as you, Nitya garu, invented thing, what would Rahul do? I would say, if I were the person whose I-140 is approved and adjustment of status is pending more than 180 days, EAD is approved, I will get married to the adjustment of status. I will use the EAD. I will forego the H1B. I will forego the H4. I don't want to keep immigration lawyers feeding, and I don't want them to be too rich. I want myself to be more richer than them. I don't want to, because it's like you are going in a flight from LA to New York. You don't need to take 2 flight tickets, one in the business class and one in economy class. You don't need to. I mean, especially I would compare the adjustment of status EAD as more business class for the price of economy class. Here is the reason is that if you want to maintain the H1B, you have to keep filing the H4 and H4 EAD extension. You have to file the H1B extension. Every time you go outside the country, you have to get the H1B stamping in the passport. You have to get the H4 stamping in the passport. These are all the restrictions. And then guess what? The consulates are closed, open. We don't even know sometimes. You have an appointment, you get canceled, all those things. Now, the whole reason why you file for this adjustment of status, even though when the final action date current, is probably not to use the H-1B.
Right.
That's the way I believe it.
Correct, yeah.
There are a lot of people who are paranoid about, I want to maintain the H-1B and green card. What if the green card gets denied? I'm not telling that the green card will never, ever get denied.
Mm-hmm.
There are chances, very, very less chances. But for that very less chances, would I keep making immigration lawyers rich? No, I will not make. That's not my motive. When I was a client, my motto was definitely not to make immigration lawyers rich. Yeah, of course, right now my motto is to make immigration lawyers rich, being an immigration lawyer. But this is an advice that I'm giving to the clients. If I were you,
what would Rahul do?
What would Rahul do? I would get married to the adjustment of status. Obviously, as exceptions, only exceptions that if there are any problems in the underlying I-140 or any criminal history, probably you need to check with a lawyer before you move into adjustment of status. And one other thing, main important thing, people who have teenage kids who are born outside the country, they have to be very careful if they want to use the EAD. If I were them, I would definitely not use the EAD. Those are the two exceptions that I feel.
Yeah, certainly the outliers, but thank you, Rahul Garba. I'm sure this has answered a lot of people's questions on Mata today. But on that note, we have a ton of people who are waiting to speak with you. So let's get on and get our first caller, Andy. And in the meantime, while we get our first caller on, there's a question from GC Aspirant who says, my priority date is June of 2010. Filed EB2 concurrently with adjustment of status in December of 2020. Still waiting for receipts. EB3 is current in final action date. Can I change my I-140 to EB3 after getting the receipt?
He filed in the December receipt notices are not getting receipted yet. They're only what we noticed recently, Nitya Garu, was the December first week is what they are getting receipt notices.
Okay.
And if you want to use the EB3 also, I mean, if you want to downgrade the EB3, since the final action date is correct though, that's a tough question. It's up to you though. If I were you, I would definitely not downgrade and file a EB3 application right now because it's going to mess up the structure of what you already filed though. These dates keep moving front and back. I can go wrong in this judgment call though, but in general, if I were him, I would definitely not file another EB3 and file an adjustment of status. I will just stay put because remember, the processing for the adjustment of status is approximately anywhere between 15 months to 45 months.
Okay.
So in this, so even if the priority date has to be current at the time when they open your file and ready to adjudicate, not right now, the final action date. So I would wait. I would not file if I were him.
All right. Thank you, Rahul Garu. And on that note, let's take our first caller, Randy. So area code 502, we're ready for you now.
Hi, Nitya Garu. Hi, Rahul Garu. Can you hear me fine?
We can hear you, sir. Hi. Please go ahead.
Yeah. Hi, Rahul. I have the situation here. So my current employer, he filed for an extension, H1 extension, but that H1 extension got denied in February. Now they have filed a new application, new H1 application from same employer with a different job title, and that was filed on a premium basis. But my I-94 is already expired with the new petition, which they have filed after the denial, after the initial denial. So I'm waiting for the response from USCIS for the new petition. Okay. On the other hand, my wife's H4 is also in pending. So that's the initial H4 extension, which was filed completely separately, and it was still pending. There was no denial on that after my H1, after my initial H1 extension was denied. So I just wanted to know, is it a default denial for H4 when my initial H1 got denied, or should I have to wait until USCIS denies the application for H4?
First thing, let's discuss about your H1B first, though. Most probably your lawyer has used something called non-protunct argument, saying that, look, there is no fault of this gentleman being out of status. Please excuse him. And under the COVID conditions, he cannot travel to India to get the stamping. Please approve the H1B. That's the argument that is made right now. I would like to get your H1B approval in premium processing right now. Once you get the H1B approval in premium processing, though, I would like your wife to go to India to get the H4 stamping and come back. The reason is that once the H1B is denied, H4 is technically automatically denied. We have a problem that once the I-94 expires and there is no properly filed extension pending, though, they would be considering the unlawful status from the time that the extension got denied. So since your extension got denied, she may be accruing the unlawful status because it doesn't have any validity for the H4, though. And by the time the H4 is going to be decided, it's going to take 1 year nowadays. So I don't want to wait for that 1 year. I would like your wife to go outside the country to get the stamping. I'm speaking only after you get the H1B approval.
You mean the new H1B petition approval, right?
That is absolutely right. And if by any chance, if the H1B approval comes with the consular processing, you both have to go to India to get the stamping.
Right. They have not applied on a non-protecting basis. Instead, they have applied for consular processing, the new petition.
Oh, yeah. If they have applied for the consular processing, there's no purpose for you to stay in this country. Both of you guys should leave the country and get the stamping.
Okay. Here is the problem. Currently, we are expecting a baby coming June, so she can do a travel at this moment as per her doctor.
Yeah, I mean, you can apply for a B2 visa right now. Wait for the baby to be delivered, and once the baby becomes mature enough, you leave the country. And both of you have to go outside the country. The H4 and EAD will be automatically denied.
Oh, no, there is no EAD at this moment. Only regular H4.
Yeah, the H4 will be denied.
Denied, okay. So we should be good to, file a change of status B2 at this moment.
You know, it's not going to be successful. It just looks decent to file a B2. It's not good because your I-94 expired. But it will look good on the profile of you by filing a B2. Why you're filing? Because you can't travel with your wife is, too much in advance in pregnancy. So apply for a B2. It will just help you look good. That's all. You're not going to get the approval of B2. Okay?
Okay.
Thank you.
Okay. But 1 second. Thank you for that. Does B2 is not depend on the B1 because there is no B1 petition, right? So can we go ahead and do only B2?
B2 is for visiting visa. You don't need B1 for B2. Okay? You're good.
Okay.
The whole family can file for B2. Yeah.
Okay.
Thank you.
Yes, sir.
Thank you.
All right. Let's go to our next caller. And in the meantime, we have a question from Venkat R. He says, can you throw some light on the present situation on biometric delays? My receipt notice for the I-485 was on October 29th of 2020.
October 29th. Right now, there is 1 million people waiting for the biometrics. Mm-hmm. They're only taking 10,000 people every day. They're accommodating only 10,000 people because of the COVID conditions. Okay. So unless COVID conditions improve, the backlog is expected to be very significant in biometrics. So if they go with the current pace, it's going to be 100 days. But then imagine that there are a lot of more people who are applying. So the backlog is very severe, though, in biometrics. Okay. So hopefully by next month, the way the vaccinations are going on, things should get better. And then based on that, the biometrics, they have a capacity to get almost like about 50 to 60,000 per day.
Wow.
So they can clear it up in 20 days if they want to. But because of the COVID conditions, they cannot clear it. So it will take long time for your turn to get in. In those biometrics also, they're giving preference to some people, not giving preference to other people. Please note that this administration may do away with biometrics for some people. If that happens, then that's going to be good. For example, for H4 and F1 and B2 and B1s, if they take those things off for I-539, I mean, 70% of the biometrics, we don't need it. I mean, previous to 2019, we didn't need to have the biometrics for at least 80% of the case, 60% of the cases. So hopefully this administration will take. If they don't, I'm expecting, because of once the COVID situation improve, they can finish the entire backlog in 20 to 25 days.
So fingers crossed, and this pandemic has brought the whole world to a standstill, but gotta move on. Thank you, Rahul Garu. And on that note, let's go to our next caller. So area code 864, we're ready for you now.
Yeah, hi. Can you guys hear me?
Yes.
Yes.
Please go ahead.
Thanks for taking the call. So my question is, I'm currently in adjustment of status with my 485 pending. And in order for me to renew my EAD and advance parole, do I need to be in the country, or is it possible to do it from outside?
You have to be in the country when you file for the EAD and advance parole. Not only you have to be in the country at the time when you file the application, if you leave the country after filing your application, your EAD will be adjudicated, but your advance parole will be denied. Even if the advance parole is approved, you cannot use it. You try to, if they do a mistake, you will suffer. If you do a mistake, you suffer. So even if they approve the advance parole, disregard it. Once you leave the country, that advance parole is not valid.
Got it. So my follow-up question is, my priority date is 2014. And my employer, they have an office in Canada as well. So is it possible for me to join, take an offer in Canada, work for maybe a year and a half, and then come back and port it to EB1? Is that possible, or will I lose my adjustment of status?
One thing is that you need to look into when you ask a question to an immigration lawyer who makes money on you. When you say, is it possible, our answer is all the time, yes. I mean, I know a person who even got a citizenship. She never even applied. She was in Calcutta. Well, her name is Mother Teresa, if you want to know. So is it possible? So is it possible? Yes, it is possible. So we can make money on you saying that it's possible, because then you give us the money, is that right? So I want you to ask the probability. That's one thing. It definitely is possible for you to go there and apply for the EB, come back and apply for the EB1A, port the date. Absolutely, it's possible. There are a lot of pitfalls in it, though. That EB1A is not an easy thing to get an approval. It has a lot of complications in it. Now, the other question that pops up is that you are in adjustment of status. You most probably filed a downgrade application. Your I-140 will be approved, and you will be free in 180 days after you file the adjustment of status. Do you need to do all these steps to expedite the green card, which we don't even know it's going to be expedited or not? Or would you just stay on the adjustment of status and don't make immigration lawyers rich, okay? Because remember, you go there, coming back, filing an EB1, it's a lot of expenditure too. If I were you, I would not go to Canada. I would not make immigration lawyer rich in this case.
Sounds good. That's all I had. Appreciate you guys taking the call. Thank you so much.
Thank you for calling. Rahul Garu, you're the only immigration lawyer I've ever met who doesn't want to be rich. So that's...
I want to be rich, believe me. I just want to be truthful, that's all.
Okay, that's fair enough, Adi. All right, let's go to our next caller. But before that, I have a question from a Kumar Batala. He says priority date is May 2011. 485 and other applications filed in October. EB3, I-140 approved, yeah. Texas Service Center. When is a safe time to travel to India? EAD advance parole pending. Any insights on when TSE backlog will get cleared?
The EADs and advanced parole, especially from the Texas Service Center, are taking a little bit longer time, though. So I would say that they're taking about 8 to 10 months nowadays. They may take up to 8 to 10 months for them to get it. The safest time definitely is after you get an advanced parole approval in your hand, and then it's definitely safer. Absolutely. I mean, very rarely anybody gets into trouble if they travel in advance parole. So I would avoid traveling this summer, wait until the EAD approval comes in and then travel.
Makes sense, Andy. Thank you so much. All right, let's go to our caller. Sir, area code 508. We're ready for you now. Hello?
Hello.
Yes, sir.
Sir, *6 to unmute your line.
Yes.
Hi,
this is Shekhar.
Hi, Shekhar.
Actually, I have filed my I-140 and 485 in October 28th of 2020. But my last, mistakenly, they sent concurrent filing. That is downloaded EB3 application, but they mistakenly sent to Phoenix Lockbox, but they need to send it to Texas Center. Actually, my lawyer is not revealing this one. Because of this, actually, they had created the 485 receipts on January 7th, but I-140 check is not yet cleared.
Yeah, that doesn't look good at all, because the 485 will be denied. Because I don't know why some people, they give the receipt notices that doesn't deserve, and some people they don't give the receipt. You definitely don't deserve to get the 485 receipt notice, because now your checks are cash and then they're going to deny your 485 application. The reason is that a 485 without the priority date to be current, I-140 will be automatically denied. So if you are not getting the I-140 receipt notice, I do not want you to rely on this 485. Even if your EAD is approved, don't use it, because they will deny this application.
And is there any chance internally they will transfer the I-140 application from one center to other center? Is there any chance?
There is a possibility for that. There's a possibility that they could transfer. Very less probability. I would say about 2% probability. There's a memo there that when an application has been filed wrong address, so they should forward it. But the question is that you may have to go to the court, federal court system, to litigate on this issue. And it may be worth for you to litigate this issue, because it's been filed with immigration, and these rules keep on changing on very frequently. So it may be worth for you to file a court litigation and have your I-140 restored as if it's been filed on October 28th.
Yes, actually, when I asked the law team, they are saying that, okay, the check is not yet encashed, and we are not able to trace your check, something like that they are saying. That is the reason.
Yeah, I do not want you to rely on this 485 application. And the court case, what I said, only employer can go. You cannot go for the court litigation on this one, though, because I-140 belongs to employer, so you don't have much authority on it. You have to completely rely on your employer. Okay? Okay then. Thank you.
Okay. Thank you very much. Thank you very much, Rahul.
All right. Let's take our next caller, Andy. And in the meantime, I have a question from VKR, Venkat, I guess. Rahul, bear with me. This is a bit of a long question. He says, we applied for adjustment of status under EB2 category in October of 2020, received receipts in November. My wife, who's a derivative, traveled to India in December, returned in Feb of 2021. I understand we have to reapply her 131 as she traveled to India while the application was in pending status. Also, we received the biometrics appointment for March last week. Do you advise to file the I-131 before the biometrics appointment? Please advise.
Yes, file I-131 before biometrics. A lot of people are somehow linking the biometrics with advanced parole and EAD. There is no link, none whatsoever at all. They are two completely different. You will get an EAD in advance parole approval even if the biometrics are not being done.
Okay.
But in this particular case, there's no reason. She came back in February. File the advance parole immediately, and of course, make sure that she attends the biometrics.
Okay, thank you, Andy. Let's go to our caller. So area code 916, we're ready for you now. Sir, *6 to unmute your line, Andy. Okay, while we're waiting on him, there's a question from Vrush. He says, if a primary applicant uses green card EAD and therefore gets married to it, what happens to the derivative applicant? Can the derivative applicant continue to work on the H-1B?
They can. I mean, they can work on the H-1B. Absolutely. There's no reason. They are still not married to the adjustment of status if they maintain the H-1B. But going to the same point, I mean, I don't know why people are hesitant in getting married to the adjustment of status. If their purpose is to make money for immigration lawyers, well, thank you. I'll take it.
Hello.
Hello.
Yeah, go ahead.
Yes, sir.
Yes, go ahead.
Hello, ma'am, and Rahul Garu. Thanks, Andy. It's a lot of help. You're taking your time and telling these answers for us. Yeah, the question is, we got EAD and advanced parole as well for 1 year, and waiting for 180 days to complete. And in Supplement J form, they put the future employment details as one of the client location, my company, which is not right. So my attorney says I had to change the company where I'll have the new 485J form, and then I should be good. Is that, hello?
I need to look into, is it a consulting company that filed that you filed your adjustment of status?
Consulting company, it's a
consulting company.
Yeah.
They put the client address in what, I'm trying to look into the form. Which page are we speaking about? Client address is there. There is only employer address. Is that right?
There is an employer address. There is in page 7 in the Supplement J form. They put one of the client location I worked before previously. I mean,
I'm sorry. I'm just trying to look into the page 7 is
page 7 and
is the extra page. Yeah. So what he's telling right now is a new employer files a 485J supplement and then you will proceed. Is that what your lawyer is telling you right now?
Yes, sir. My lawyer is telling we'll go to another company where they will give a correct, he will be working in any other location within the United States of America. It's not particular to one client location. He can work anywhere. That kind of thing they will give it sense, and that will resolve the issue.
I don't know why that has been an issue that you have put the client address on page number 7. That's an addendum that you're speaking about. I don't see as a problem that what you have already done, but the step that your lawyer is taking is definitely doesn't look to be harming at all under any conditions. It looks to be fine to me. If you have a new employer and you file a 485J supplement, you'll be fine. I don't see any problem.
Okay. Awesome. So another small quick question. So once 180 days is completed, can I work 2 full-time jobs, 40 hours?
Yes, you can. You only need one. You absolutely can. Absolutely can.
Okay, sir.
And you absolutely can. And the 485J supplement doesn't have to be filed by 2 employers. You only need to be filed by 1 employer.
Yes, sir. Yes, sir. I got you. I got that one. Yeah. Yes, sir. And I will reach you, sir. I'll send my documents. Okay. Thank you, sir. Those are my questions. Thank you. Thank you, ma'am.
Nitya, he raised another point where he's going to make more money because of the EAD. He's going to work for 2 companies. And guess what? He doesn't need any lawyer to work for 2 companies. He just use the EAD, make 1 more extra copy. That's it. 1 cent, 2 cents. Now, if you want to work for an extra company, 2 companies on H-1B, That's a lot of money for the company, of course, not for you, but it's a lot of strain. Look, it's cheap, it's free. Just make one copy, 2 cents, give it to the employer, and you can work. That's another reason I wouldn't get married to the adjustment of status.
Correct. No.
Yeah, I mean to say 2 jobs when on EAD though.
Absolutely, yeah. That's what you're good. Work 2 jobs on EAD, make a copy of EAD, and then give it to the new employer. That's it. You don't need him.
Awesome. Thank you, sir.
Thank you so much for calling, Andy. All right, on to our next caller. But before that, I have a question from Bobby Manuel, Andy. This is about the HR 6 American Dream and Promise Act of 2021. He's asking if it includes H4 legal kids.
I don't know about this. What is the number he said? HR what?
HR 6.
I don't know about, I did not study about the HR 6 bill though at this point of time.
Okay.
I have no knowledge about it. There are so many bills pending for the immigration at this point of time. The most important bill that is pending right now is HR 1177, which is also called as U.S. Citizenship Act of 2021. So in this U.S. Citizenship Act bill though, the H4 kids are protected if they are under 18 years. By the time they got their H4, they are protected. They would get the green card even if they get aged out. But I'm not aware of this other bill the gentleman is speaking about. There are many bills that have been presented though, but the serious bill right now to consider is only HR 1177.
Makes sense. I somehow feel like this is about the DACA kids. I think, it says American Dream and Promise Act. So maybe I'm wrong, but yeah. Thank you, Rahul Garu. On that note, let's go to our next caller, and it's area code 667. We're ready for you now. So please press *6 to unmute your line, Andy.
Hi, Nitya and Rahul Garu.
Hello, sir.
Yes, sir.
Yeah, thank you for taking my call. So my question, Rahul Garu, and my company actually November 3rd last year, I-140 plus 485 concurrent filing chesaru.
That's good.
So February 12th రోజు నాకు రిజెక్షన్ నోటీసెస్ వచ్చాయి. టోటల్ 7 రిజెక్షన్స్ ఇంక్లూడింగ్ మై వైఫ్ యాజ్ వెల్. సో రీజన్ ఏంటంటే I-140 ఇన్కరెక్ట్గా ఫైల్ చేశారు అని వచ్చింది. సో మా అటార్నీతోని మాట్లాడి I-140 మొత్తము రివ్యూ చేసిన తర్వాత తెలిసింది ఏంటంటే పేజ్ నెంబర్ 6 వచ్చి 2018 ఎడిషన్ విచ్ డజంట్ హ్యావ్ ఎ బార్ కోడ్ అండ్ ఆల్ అదర్ పేజెస్ ఆర్ 2020 ఎడిషన్ విచ్ హ్యాస్ ఎ బార్ కోడ్. సో అటార్నీ ఏమో ఇది కాంటెంట్ అంతా సేమ్, కానీ వర్జన్ ఎడిషన్ ఒక్కటి ఆ పేజ్ నెంబర్ 6 వేరే ఉంది. సో యాక్సెప్ట్ చేస్తారు అని రీసబ్మిట్ చేస్తాను అంటుంది. ఇది వర్కౌట్ అవుతుందా అవునా?
You should go to court though. I recall that I went to appeals one time on the same issue. What happened at that time was that the online system got locked out. And we had to file an application for the perm application. And the logo on the top was not there, and they denied the perm application. So we went to court. I don't remember where we went to, but we got that one overturned by the Labor Department. Oh, wow. If you should try. If it is not successful, though, I would definitely go to the court to get it up, because these are the things we cannot file it later on, is right? These are not the things. So you have to go to the court system and try your luck there to see if they would take it. It has been tried successfully before, though. Not in the, if sometimes they take it. I'm not telling that they won't take it. If they take it, that's fine. If they don't take it, I want you to go to the court system and get it done. And believe me, the court system is not that expensive, especially after the Trump came in. The immigration lawyers who never used to go to the federal court started going to the court, including myself. And we filed so many lawsuits, and we did very good. Previous success is not a guarantee that you would be successful, but I'm just telling that we are able to go to the court system, learn the new things. We're able to file a lot of complaints, and that's a good way of getting. So you may want to seriously consider that, though, if your application is not accepted. But it has to be done by your employer, not by you.
Okay, thank you. And ingo quick question. Recently, USCIS OPT-ki retain and refile ani oka opportunity.
I have seen that.
So similarly,
you're absolutely.
Yeah.
I've seen the article,
so
yes.
Similarly, Yes. So 485 ఇప్పుడు నాకు రీసబ్మిట్ చేయడానికి డేట్స్ కరెంట్ లేదు.
Well,
సో
they haven't given that to us at this point of time. Would they give it? Would they not give it? I don't like to wait for that long. I would like to refile it, and I want to use the court system. If by any chance they issue the same kind of memo for you, bingo, you got it. You will go in there. But I don't want you to wait for it.
Okay. Thank you, Andy.
Thank you, sir. Thank you so much for calling. Let's go to our next caller, Andy. And in the meantime, I have a question from 𝗟𝗩𝗘 He says, I've never traveled to US back in 2014. Employer A filed an H1B for me. It got picked in the lottery, got approved till 2017. When I went for visa stamping at the Chennai consulate, I was given a 221G. Case was sent back to USCIS and it got revoked in 2017. Now I have an employer B who's ready to sponsor the H1. Am I eligible for cap exempt or should I go through the regular cap quota? Earlier H1B can be used and transferred to my new employer?
No.
Okay.
If the H1B is not stamped in the passport, there are two ways the H1B can be counted. One is it's been stamped in the passport or you have a valid I-94 of the H1B. In this case, he neither had an I-94 nor he had a passport stamping in the H1B. So he is not counted toward the H1B. He has to go through the lottery system again.
Okay, got it. Thank you, Rahul Garu. All right, on to our next caller, Andy. So area code 214, we're ready for you now.
Hello, Andy. Nitya garu, Rahul garu.
చెప్పండి, please.
Yeah, Rahul garu, thank you so much for all you do, Andy. మేము మీ షోస్ అన్ని రెగ్యులర్ గా ఫాలో అవుతున్నాం అండ్ చాలా ఎడ్యుకేషన్ వస్తుంది మాకు అండ్ ఆల్సో లైక్ వీఆర్ స్ప్రెడింగ్ ద వర్డ్ టు అదర్ పీపుల్ టు హూ ఎవర్ ఈస్ నాట్ ఫాలోయింగ్ యూ.
Thank you very much.
సో క్వశ్చన్ ఏంటంటే మీరు చాలా సార్లు నేను అంతకుముందు కూడా మీతో మాట్లాడాను, నా పేరు వెంకట్ పడాలా. సో రిగార్డింగ్ ఒక ఇమిగ్రేషన్ ఇష్యూ గురించి, ఒక ఫేక్ ఈమెయిల్ గురించి కూడా మాట్లాడున్నాను. సో నా క్వశ్చన్ ఏంటంటే మీరు ఎంతకుముందు 2-3 సార్లు మీతో మాట్లాడాను, మీరు చెప్తారు I-1 485కి 485 అప్లికేషన్కి 765కి బయోమెట్రిక్స్ కి సంబంధం లేదు, అది విడిగా కూడా అప్రూవ్ అవ్వచ్చు అని చెప్తున్నారు. బట్ నాకు నేను లాస్ట్ వీక్ బయోమెట్రిక్ అపాయింట్మెంట్ వచ్చింది అనమాట. దాని మీద క్లియర్ గా మెన్షన్ చేసాడు, 2 నెంబర్లు పెట్టాడు, 2 అప్లికేషన్ నెంబర్లు, 765ది 485ది. ది బయోమెట్రిక్ ఈస్ ఫర్ వాటికి అని చెప్పాడు. అండ్ ఇంకోటి ఏంటంటే సమ్ ఆఫ్ మై ఫ్రెండ్స్ హూ ఎవర్ అటెండెడ్ బయోమెట్రిక్స్ దేర్ EAD is getting approved within a week.
No, there are a lot of cases. There are a lot of cases that got approved, EAD approved without biometrics too. That's one thing. Second thing, let me tell you one thing. When you file the EAD extensions, there is no biometrics at all.
Okay.
That's a simple example for you. When you file the H4 plus EAD extension, they have to have a biometrics. Guess what? When you file for EAD, absolutely no, there's no biometrics.
అండ్ ఇంకొక ఫాలో అప్ క్వశ్చన్ అండి. నాది 2011లో ఫస్ట్ టైం 140 అప్రూవ్ అయింది, తర్వాత 2014లో అయింది. ఎంప్లాయ్మెంట్ మారిన తర్వాత లాస్ట్ 9 years ఒకే ఎంప్లాయ్ దగ్గర ఉన్నాను. నేను మామూలుగా EAD వాడుకోవచ్చు అంటారా, లేదంటే లేదు అంటే మామూలుగా ఒకవేళ వన్స్ EAD అప్రూవ్ H1B కంటిన్యూ చేయమంటారా? మా లాయర్ వచ్చి H1B కంటిన్యూ చేయాలని చెప్తున్నారు.
Well, I want this kind of building for me. So if you continue on the H1B, I will get it. I have to answer this as if that I am the client here. There are a million people. I mean, out of the 400,000 people, there could be one guy. That might, 1 or 2 guys that might get into trouble. Because of that, you want to maintain 400,000 people's H1s, H4s, EADs, and then you have to go every time you go outside the country, you get the stamping, visa stamping.
Stamping has it.
I'll make a down payment. If you would choose the H1B, let me know. I'll make a down payment.
You deserve it. You deserve it. You deserve that house, definitely.
Okay.
The service you do to the society, you definitely deserve it. Thank you so much.
No, but just because you want to pay a lawyer, don't do a murder, okay?
Sure. Thank you.
Okay. Yeah. So it's just like that. You love the lawyer. You don't do wrong things. I mean, that's bad. You should, the whole legal system should be designed in such a way that you should try to avoid the lawyer. I mean, believe me, That is what they teach us in the law school, is try to avoid the lawyer as much as you
Sure.
can. So just because you want to pay some lawyer, you're not going to do murder. So simple thing, try to avoid lawyers. You become rich. Don't worry about me. Okay. Thank you.
Thank you. Thank you so much. Yeah.
Thank you, sir. Thank you for calling in. All right, Rahul Garu. Let's go to our next caller, Andy. But in the meantime, I have a question from 𝗟𝗩𝗪 𝗪𝗪𝗧𝗛. She says EB2 priority date is May 5th of 2010. October 20 adjustment of status applied in EB2. March 21st. EB2 final action date is July 10th. I-140 downgrade application in progress. Do I have time until end of March of 21 to apply for the EB3 downgrade to reach the USCIS?
So our priority date is 2010, is that right?
Correct. May 5th, 2010. Yeah.
10. And then she already filed the adjustment of status application. If I would not choose to downgrade my application if I were 𝗟𝗪𝗪. I would not choose. That's my choice. Unless the only exception is that if she has any teenage kids, though, I would definitely consider downgrading because you want your application to go through the final action dates to be current. Otherwise, I would not file a downgrade application. As same pointing out is, don't make the immigration lawyers rich unnecessarily.
Okay. Thank you, Rahul Garu. Let's go to our caller, Andy. Sir, 847, we're ready for you now.
Hi, Nitya Garu, and hi, Rahul sir.
Hi, ma'am.
Hi.
Yeah, thank you so much what you do. So I have a question. If I right now I am on a H4 EAD and we apply in October 485. And my question is, if I open a company on EAD card and we did not get 485 EAD yet. So if we open a company on EAD and after we get 485 EAD, so is that any problem to transfer? Okay.
Well,
so we can do norm. This is.
Is there any transfer from this? No, there is no transfer. You have an EAD now. You have an EAD later on. You don't need any paperwork. Nothing. None whatsoever at all. If ever your H4 EAD expires, the I-9 need to be updated if you're working for that company. Yeah, that's easy. Just make one copy of the EAD and then put it in there, update in the I-9. That's about it. Not a much paperwork at all. You don't have to go to any immigration. You don't have to go to an immigration lawyer. You don't have to do anything. It's easy. Just update the I-9, make one extra copy, 2 cents it costs for you to make a copy of the EAD.
So this is for the just transfer company H4 to EAD. If I do own a company, if I open a company, so just I-9 form.
Just I-9 form.
And quick, thank you so much. And a quick question: I apply a B2 extension for my mother 2 times. Can I apply? First is approved, second is pending, and she's got first COVID vaccine, but her extension time is in between. So can I apply one more extension, and after that, within a month, she can go back? Any problem with that?
I didn't like the 2 extensions because, of course, we are in the extreme circumstances. But if the second extension time is expiring, and then she has to stay here for 1 day more, you still need to apply for the 3rd extension. Even though second extension is pending, you still need to apply for the 3rd extension. Because if you don't, though, the passport visa is considered to be invalid. So she cannot come back using that.
If the second is denied?
But if she leaves the country, okay? If she leaves the country and the second gets denied, she is fine. But if she is in the country, if the seconds get denied, though, we consider that her I-94 has already, we consider her that she stayed unlawfully in this country for a certain period of time. That means since the time the denial all the way to the time she boards a flight. And her passport visa will still be considered invalid.
Okay. Okay. Thank you so much, sir.
Thank you.
I appreciate it. Thank you, Nitya Garu. Bye-bye. Thank you.
Thanks for calling. All right, on to our next caller, Andy. And in the meantime, we have a question from Shankar Krishnamurthy. He says, if I apply for H4 to F1 conversion for my son today, and 6 months down the line, if my priority date becomes current and F1 is still in processing, can the F1 application be withdrawn?
I'm assuming that he's speaking about, I guess, is the final action date is current.
Yeah.
I'm assuming that. Yeah. Absolutely. F1 can be withdrawn. No problem with it. F1 should be withdrawn. If the final action date becomes current, you already filed the adjustment status. You don't need F1. You don't have to pay that extra out-of-state tuition. You don't have to go through all the bureaucratic work. You can withdraw it. Absolutely no problem with it.
Okay. Thank you, Rahul Garu. On that note, we'll go on to our next caller, Andy. It's area code 848. We're ready for you now. Sir, *6 to unmute your line, Andy.
Yeah, hello.
Hello?
Hello. Hi, Nitya Garu. Hi, Rahul Garu.
Hi, sir.
Yes.
Chapman, sir.
Yeah, hi. Nadi, mine is H1B approved without I-94 extension in February 2020. And since there was no I-94, immediately I was out of job, the client place which I was actually approved for. And I was able to travel, but in March, the lockdown started and I couldn't travel at all. Finally, in June, I guess, we had the President proclamation on the H1B's thing. July first week, I had to travel to India. And from then on, I'm just here, and there's no consulate open, at least until recently. So now my question is, since the H1 that I applied for, the client, I'm not there anymore, and I'm here in India, but I have to attend a visa interview. Can I still go ahead with this current approval?
No. Withdraw the application.
Okay.
You will get a bad remark on you because you don't have a job that is prescribed in the underlying H1B. Since you don't have a job under the underlying prescribed, that's a wrong thing to go for the interview. Withdraw your application immediately.
Or how about do this, get a job and do an amendment on the current one? Is that
you can do so. You can do so, but you have to wait for the amendment to be approved before you go to the interview.
Right. Yes. Okay, I got that.
Yeah.
And
If you have the amendment approved, I would just send an email to the U.S. consulate saying that, look, I'm coming for the interview, but here is the petition that I'm coming, not under the old petition. And then you go for the interview. That should be fine.
Okay. And also the other part is my priority date is EB2 July 2011. And I think right now it is May 2011 the filing dates are. So I'm in very desperate situation to come back and do the filing for the GC also. But since I'm here, can I just do a downgrade from here to EB3? Is it possible to file that?
No, you can. Absolutely, you can. You can downgrade the application right now.
Okay, because I'm not in the country, right? So is it still okay?
Not required. No, it's still perfectly okay for you to downgrade the application. While you're in India, you can file an I-140. No restriction, none whatsoever at all on that.
Perfect. So I think maybe instead of scrambling for the H1 interview, I should have initiated the, maybe let me just talk to my employer and initiate the downgrade.
But I still like your plan of coming into United States and converting an adjustment of status. Don't expect your downgrade application to be approved and then immediately consulate will call you, hey buddy, come here, get the green card. It's not going to happen that quickly though.
No, I know. It will take a while to...
Yeah. Right. So I would still file an I-140 application in the downgrade. Go ahead with the consular processing though. Even though you do consular processing, technically you can still do the adjustment of status. So go ahead, file the I-140 with the downgrade with the consular processing. If the things get through in India, that's fine. If the things don't get through, your plan A should be coming back into the United States on H1B and then converting into adjustment of status. Plan B is consular processing for you.
Right. Yeah. Okay. All right. I think that helps a lot. Thank you, Andy.
Thank you, sir. Thank you so much for calling. Let's go on to our next caller. And in the meantime, we have a question This is from Divya C. She says, I have H1B stamped Jan 2020 and I'm now working from Canada. If I relocate to US from Canada for the same client, do I need an H1B amendment since it's more than 1 year from the date of the visa stamping?
Technically, you don't need an amendment because you're working for the same client. But when you're entering into the country, though, be very careful because there may be a doubt with the CBP that you don't have a job at the end client. They will doubt whether you have a job or not. Most probably, if you're remotely working for the company, I mean, try to document everything that you can. If you are not remotely working, also have one of the HR company person of the end client and your company, both of them, to be available to file it, because when you're in the airport or at the port of entry, they may call these people to inquire if there is a genuine job opportunity or not. And then there should be a person that should answer the call and make sure that, you know, you're late. That's the only doubt. But technically, amendment is not required.
Okay. Thank you, Rahul Garu. Let's go to our next caller, Reddy. So area code 646, we're ready for you now. Hello? Okay, while we're waiting on our caller, there is a question from R.K. Ram. He says, when H4 dependent case is pending, waiting for biometrics in September 2020, can they stay in US while on an H1, travel outside for an H1B visa stamping?
What biometrics is done or not done?
It says waiting for the biometrics in September of 2020.
Yeah, they can. If you're waiting for the biometrics, you can travel outside the country. And I'm assuming that the advance parole is not approved because people link advance parole and biometrics unnecessarily. But if the advance parole is not approved, you can definitely travel outside the country and get the stamping and come back while the additional status is pending.
Okay.
If the biometrics has not been done, you can still travel outside the country and get the stamping done in India and come back.
Okay.
But my recommendation is just wait for the advance parole. And once the advance parole is approved, you don't have to go for stamping.
Okay.
That's my advice, but technically you can still go and get the stamping. Yes, sir, go ahead. I'm sorry.
Yeah, please go ahead, sir. We're ready for you now.
Yeah, sorry. Thank you, Rahul Garu and Nitya Garu. So my priority date is March 2012. So my EB3 140 got approved in 2013. And I ported from EB3 to EB2 in 2014 with my current employer. So EB3 was with my previous employer. So my lawyer advised that as EB3 is active, so he did through 485J. So how he is showing is company acquisition or through merging, because my employer was partner with the previous company. So without downgrading, he filed straight EB3 in October 2020.
So let me understand the thing. You got EB3 approved with company A. You got EB2 approved with company B, where you ported the date from EB3 to EB2. When you file the adjustment of status, it's the company B that filed the 485 application using company A's I-140 approval.
Yeah, that is correct.
And then you did not file any I-140 amendment.
No, he directly did with the 485J only, no amendment.
That's okay. This amendment is different and downgrade is different. I just want to note that one for you. That looks very odd because if there is any company change, tax ID number or any company change though, you are supposed to file an I-140 amendment. Since you're filing the adjustment of status with company B though, you should file an I-140 amendment. Now that's a wrong strategy of not filing an amendment. Do you know if the 485J supplement has been signed by employer A or employer B? Which one is listed?
Employer B signed.
No,
employer B signed on it.
Which company is listed on 485J supplement? Employer A or employer
with
B?
the current B only,
Employer
with the current employer. Yeah.
I would, that's not a nice way of doing it though. I don't know how they did it. I wouldn't have done that way. I would have done only either have employer A file the 485J supplement or file an I-140 amendment and file a 485J supplement for you.
Yeah, the problem is the employer A no longer exists because it's acquired by B.
But you could have just filed a downgrade application and filed the adjustment of status.
Yeah, for some reason he suggested this instead of downgrading.
It's definitely a wrong thing according to me. I want you to get an advice from an independent lawyer rather than the lawyer who advised you. I'm not agreeing with your lawyer in this case. Okay?
Yeah.
Thank you.
Yeah, so the follow-up question here is, so I mean, I got all the receipts and I also received a biometric appointment for this month. And I was expecting the EAD to come. So whether to use the EAD or not, because my kid is 14 years now.
First, you should not use the EAD because you have underlying problems with I-140. You have underlying problems everywhere. You should not use the EAD.
Is there any way we can rectify this? I mean, can you
I would like to, I would want you to have an independent lawyer review all your I-140s, and then only you should take the step of using the EAD. Until then, don't use the EAD. That's my advice to you right now. Okay? But I cannot open up all your files and give you an advice right now, but I strongly recommend that you contact a lawyer.
Okay. Thank you so much, Rahul.
Thank you, sir. Thank
you.
Bye. All right. Let's go on to our next caller, Andy. And in the meantime, we have 𝗓𝗪𝗪 𝗪𝗪𝗧𝗛 says, thank you for all the work. If we are, Rahul Garu, 1 second only. Sir, area code 225, can you please, mute your line. We'll be back with you. He says, we are first time filing. What is the advantage of 140 in premium if priority date is also locked?
Can you, I missed out the question. Can you repeat the question?
He's filing for the first time, and he says, what is the advantage of filing premium processing if priority date is also locked?
Priority date is locked. I got his point, what he was saying.
Okay.
If you're not filing an adjustment of status and your priority date is already locked, what he meant to say is that his previous I-140 was approved for more than 180 days. That's what I'm assuming, though. Yeah, I mean, if you're safe from the previous I-140 was approved and was not withdrawn for 180 days, and you are filing an I-140 right now and the priority date is not current, no need to file premium processing. No need to file premium processing.
First time filing, so that's kind of...
Even though he's first time filing with this company, he had the previous I-140 priority date locked. That's what I'm assuming, though. But if he's first time filing, he never had an I-140 approval. The advantage of filing the premium processing is you don't know when you're going to leave the job. You don't know when you're going to leave the country. You don't know what's going to happen. It's better to get an I-140 approval and 180 days pass as quickly as possible.
Okay, that makes sense.
That is if you're filing the I-140 first time. But if your I-140 date is locked with the previous employer, yeah, I'm fine. I wouldn't spend $2,500 if I were him.
Okay. All right. Thank you, Rahul Garu. Let's go to our caller address, area code 225. We're ready for you now. Please press *600 to unmute your line. Hello?
Hello. Can you hear me?
Yes. Yes.
Go ahead, sir.
Thanks, Nitya Garu. Thanks for taking call. Thanks, Rahul Garu.
Thank you.
Thank you, sir.
Sir, I have a question. I filed my previous employer filed my 485 application with a EB3 downgrade. I'm still with a different employer, but I'm planning to go back. So what are the repercussions of joining or going back late? Like, because I have to stay with the current employer for a certain amount of time.
Well, there's no requirement for the green card purposes. You're safer joining the previous company. So when you're saying repercussions, what do you mean? Which angle are you telling?
So let's say if I just directly wait until 6 months on 140 get approved and I just file the 485J with a new employer, how does that work out when I go to the interview?
Yeah, previous. I think, yeah, one, there is a small element of risk, though. I wouldn't say that it's a big element of risk. It's that the USCIS may question whether or not the employer had a genuine job opportunity open for you from the period of October of 2020 all the way to April or June, whenever you are going to file the 485J supplement with the new company. They may question it. But if you're going to ask me a question, have I seen any denials because you never joined the company that filed the 485 application? Have I seen any 485 or adjustment of status denial? Let me tell you the answer. No, I have not seen it. I'm just saying that there is an element of risk. It doesn't mean that I have seen a denial. They may question it. So that's a small amount of risk that you'll be taking if you don't join the company that filed the adjustment of status.
Okay. Is it okay if I join in the next 6 months? Or is it still going to be that
as
element of risk?
As I said to you, there is about 2 to 5% element of risk of questioning it, okay? Not a denial, questioning it. And, you know, out of every million cases, one will be blasted, right? You never know. The officer may think differently. Do they have an authority? Yeah, they do have an authority to check whether or not there is a job opportunity. It may create trouble, but it's up to you. I mean, are you willing to take that 1%, 1% risk of getting in denial, or are you not willing to take that 1% risk? That's up to you.
Okay, so just extending on that. So let's assume that 1%. What happens if that 485 application is rejected at the final stage? Where should I be starting where will I be starting my next application?
It's definitely where you will be starting your next application will be. Your I-140 priority date is good for you. So I don't see any problem with your I-140 priority date. You may have to file another H-1B if you are already married to the adjustment of status, and then go outside the country, get the H-1B stamping and come back and file a fresh labor and I-140. So it may take up to 2 years for you to get back to adjustment of status.
Okay, but my PD will still be with me.
I don't see any problem with your priority date.
Okay, thank you so much,
Okay.
Rahul. Thank you.
Thank you.
Yep.
But these are genuine questions, 𝗧𝗟𝗪, what this gentleman asked. A lot of people have filed adjustment of status without working for the company. So it's a good question, and this is just 1% element of risk that I just want to point out to everybody.
Yeah, I can imagine, and there's an infinite, sort of permutations and combinations you can put together for people's situations. All right, Andy, on to our next caller. But in the meantime, I have a question. This is from Praveen DS Data Science. He says, my spouse's H4EAD is valid until the end of November of 21. Can we apply for an H4EAD extension now?
November
of this year.
So he's going to file for H4 or H4 plus EAD. He can apply for H4 plus EAD.
Valid, and he wants to extend the H4 EAD.
What his question is that it's more than 6 months that his wife's H4 EAD is valid. Can he apply for it?
Yes.
I have seen so many people applying. I personally, as a lawyer, applied for a lot of people. Our channel covers, we get about 25,000 views here every week. And people report to us, and I read some of the notes that are there too. For all the people who filed more than 6 months, nobody got rejected.
Okay.
Nobody got rejected. There was only one case. It went to RFE. They have consulted me, and I have helped them in responding to the RFE. I gave them the content to it, and they informed me back saying that their EAD got approved too.
Okay.
So there was only one RFP out of all the thousands of cases.
Okay.
And that was resolved in our favor. So that's all, if I were him, I would apply for an EAD.
Okay. Got it. Thank you, Andy. Okay, on to our next caller. So area code 330, we're ready for you now.
Hi, can you hear me?
Yes, sir.
Yes.
Please go ahead.
Hi, thank you for everything you do, Nitya and Rahul Garu. So my question is, I have applied for my 485 in October 2020 in EB2. So my biometrics has been scheduled in next week, but I need an emergency advance payroll due to a family emergency in India. So the question is, I've already applied my 131 with my 485 petition. If I apply for an emergency advance payroll, do I need to refile my 131 with the applicable fees?
There's no fees.
Oh, there's no fees? Okay.
Yeah.
So, but
I would, when you make an appointment for these people though, since there is no fees though, I would fill an I-131 application. I will take the passport size pictures there. Okay. Because if the local officer wants to make an emergency decision, he doesn't want to go back to the service center and get the whole file and the pictures are not there. In your case, if you provide everything for him, it makes it easy for him to get it approved.
Got it. Okay. So another question is, this emergency AP, is it only applicable one time to go out of the country and get back, or
some of the officers will give only for 30 days. Some of the officers will give it for 1 year. Some of the officers will give it for 2 years. I don't know how long they're going to give it. Whatever the date they give it, I will definitely go and honor that one.
Okay. Yeah, thank you so much. Is there any other, for how many days do you think it might, is it safe to go on this emergency AP, or should I wait until I get my EID card, the regular AP and EID card combo?
If you get an advance parole for an emergency granted though, yeah, it's pretty safe. I don't see any problem in you going outside the country and coming back. I don't see any problem whatsoever at all.
So in case I'm not able to come back within, say, 30-day period, then will there be any problems for my 485 petition?
I don't know about that other family. This family will be in trouble now. I thought your family is here now. I don't know what family emergency you have, but whatever family emergency you have, this family will be in trouble. I definitely don't want you to do that. That is ridiculously wrong thing. It's like going and taking a stone and banging your head on it. Okay.
Yeah.
Don't. Yeah. Under all conditions, and don't try to fly 2 days, 3 days before that. I would fly 1 week before that time. Believe me, under the COVID conditions, you don't know what's going to happen.
Sure. Agreed. Yeah. Thank you so much. That's all my questions.
Thank you.
Thank you for calling.
Thank you.
All right. Now we have a question from SVT Stocks. He says, Dependents 485 package was returned due to improper filing in October of 2020. What are the chances that USCIS allows for refiling? Is your company Reddy Neumann P.C doing court litigation so we can join?
It's not going to be a court litigation for a lot of people. If you're interested in, you can contact our litigation lawyer. His name is Stephen Brown in our office. I would, before I go to the court litigation though, I would refile it and have it rejected second time before you go to the court. Because there is a chance, as he was asking, there is a chance that they may accept it though, even though the prior dates are not current. We have seen that officially they have issued a memo on the OPT and STEM extensions when you have some technical issues and they rejected your application, even though the USCIS was right in rejecting the application, they're accepting the OPT and STEM extensions for for minute reasons though. So there is a good chance that they may accept it. If they don't, then only second time, then I will go for the litigation. Otherwise, I will not directly go to court litigation.
Okay, that makes sense. Thank you, Rahul Garu. Let's go to a caller, Andy. So area code 248, we're ready for you now.
Thank you, Nitya Garu. Can you hear me?
Yes, sir, we can. Please go ahead.
I have a couple of questions for Rahul Garu. Hi Rahul. My first question is, I have an approved I-140 and I got a new offer from another employer. So for the H1B transfer process, do I need to give a copy of I-140 to the new employer? And also,
how long it's been the I-140 has been?
180 days. 180 days is completed. 180 is completed.
You don't have an I-140 approval in your hand?
I do have.
Okay. Yeah. Well, give it to him. What's wrong?
I mean, I also have the FOIA copy as well. Do I need to give that copy as well, even if requested or not by the new employer?
If the employer requested, give it. If the employer requested, give it. I mean, what is he going to do? He can't do any damage with it. It's a public information anyway.
Okay.
So, if he requests, just give it to him. I would, if as a lawyer though, I would not require the, I would like to have the documentation. I would like to have the freedom of information also. The reason is that I want to know when it's been withdrawn. So I would, if I were your new employer's lawyer, I would like to have all these things. I will give it to him.
Okay. And the other question is with regard to the dependents. So my dependents extension with the existing employer, with my existing employer, got approved only on Friday, which is day before yesterday. So now I have not got that approval notices in my hand. So will it be okay to not file their extension with the new employer, even though I don't have the physical approval notices in my hand? Maybe they are on the way, or maybe even if it's delayed.
If you're thinking that because you don't have the H4 approval, filing an extension is a problem, no, it's not a problem. Even if your wife's H4 extension has not been approved, you can use the receipt notice that you filed to file the H4 extension though. So if that's the reason you're thinking, go ahead, use the receipt notice and online approval, and then tell him that it's approved but I don't receive it, and that's fine. But if you're thinking that do I need to file? Why do you have to spend all this money again? Yeah, you don't have to immediately file a H4 extension. You can do it later on though.
Okay, that's the point. And will they need to attend biometrics again if we apply again?
There is a chance they may request the biometrics again. There is a chance they may use the already biometrics done for your wife. It's up to the officer though.
Okay, I get it. Yeah, that's all I have. Thank you very much.
Thank you.
Thank you, sir. Thank you so much for calling in. All right, folks. We have a lot of callers still waiting and a lot of questions to get through, but we're all out of time for today. Rahul Garu, thank you so much for being so patient with all of our callers and viewers and for answering all of their questions on MATA. And, like you said, we have a new segment now called What Would Rahul Do? WWRD. So continuing in that, spirit, thank you so much for being again here on the show. And
thank you, Nitya. Thank you, TVASIA.
Same time, same day. And till then, you guys have a fabulous, fabulous week. Okay? Bye.